I've talked about a couple of things in prior videos that I want to come back to and reinforce today. One is that the sexual harassment law leaves room for judges and juries to make interpretations. And even if the statutes don't change federally or in a particular state or locality, I think the law can change as judges and juries and other decision makers act differently in that room to operate. Secondly, I talked about a case from the Third Circuit, which is a federal appeals court that includes Pennsylvania, a case out of Pennsylvania where an individual was able to go forward with her harassment case even though she had not complained to Human Resources, which was pretty unusual. I've got an article here in a major news outlet from just a few days ago where one of the commissioners of the Equal Employment Opportunity Commission sort of comes back to these couple of things. The EEOC is the federal body, as you may know, that is charged with enforcing Title VII. So it's important to regulations, it's important to charges that you may have from employees. There's just one of 5 commissioners, but that's an important voice in this area. She references that Third Circuit case that I talked about before, and she says, it's a little too early to tell if this is going to be a long-term shift, but some courts have been making decisions that I think would have come out differently a year and a half ago. I agree with all that, and I think this captures, with a voice that's more important than mine, some of the things that we talk about here. So what's that mean for the employer? Certainly, you got to be good on the nuts and bolts. If you're not already, got to have a good policy, a policy that leaves as many avenues for reporting as possible. I'm not a fan of leaving it open for just a couple of ways to do it. However the company gets the information is good because we want the information. But the other, and we've got to investigate when we get things and react well, but the other thing we need to do, I think, and I've said before, we need to think about and find new ways to be aware of harassment, because what Me Too has shown us is or at least reminded us of the scope of unreported harassment. So you're seeing electronic tools out there where people can report anonymously, which we used to not encourage. Maybe use those. There are apps. There are other things. Maybe there are more regular, smaller conversations than your annual official training and what have you, which is, again, part of the sort of traditional nuts and bolts. This is not a doomsday scenario. That I think this is very doable for employers who want to do it, both for liability prevention reasons as well as just a healthy workplace. But this reminds us that I think we really need to be all working on that together.